Bismillahirrahmanirrahim. Sources of international law, as we had discussed in previous lectures about sources of international law, and in last lecture we discussed the customs as a source of international law, and inshallah in this lecture, in this video, we will discuss treaties as source of international law. This would be part third of lecture 5. Treaties. Treaties are also the most important material source of international law. Treaties are basically purely material source of international law, and the importance of treaties as source of international law is increasing with passage of time. The nature of the treaty expresses the effect of any treaty regarding formation of rules of international law. Definition of treaty. The best definition is in Article 2 of the Vienna Convention of the Law of Treaties 1960. An agreement whereby two or more states establish or seek to establish a relationship between them governed by international law, that is called treaty. Classification of treaties. There are different classification of treaties, but on the basis of nature of treaties, they can be classified as under. First one, law-making treaties. Law-making treaties are those which provide rules of universal application. The law-making treaties are the direct source of international law. It is very important that law-making treaties are direct source of international law. The role of law-making treaties in the field of international law is the same as of the role of legislation in the state law. Since the middle of 19th century, the treaties have seen great importance in sources of international law. It is also not fact that the provisions of lawmaking treaties always have the universal application. Therefore, lawmaking treaties may be divided into two kinds. First one, treaties giving the rules of universal application, i.e., that is Charter of UNO, and the second one, treaties providing general or fairly general rules that have no universal application but have a general application and fair position for decision between conflicting parties. Criticism on lawmaking treaties. The critics of the lawmaking treaties have said that these treaties do not provide the rules of law as are the outcome of the contractual obligations which the state parties are to respect. They also have the view that these treaties overlook the astonishing development of lawmaking treaties as source of international law and their adoption by the organs of international institutions such as General Assembly of UNO and Conference International Labour Organization. Normative treaties. Some conventions and instruments are required to be ratified by states for their enforcement, but some of them are not even expressed on the consensual form. These treaties may be designed as normative treaties. Normative treaties have following kinds. First one, treaties working as general standard setting instrument. For example, General Agreement on Tariffs and Trades of October 1947. The second one, unratified conventions subscribed by a large number of states. Closed treaties open for signature by a restricted number of countries. Treaties formulating community rules. Treaties creating any internationally recognized status or regime to some extent. Instruments such as final acts to which are annexed international regulations intended to be applied. These all are forms of normative treaties. The third one is interagency agreement. Interagency agreements are agreements between international organizations and even between an international organization and a state. These agreements may also be a normative in the sense that they have laid down norms and general application in certain cases. Binding of multilateral convention on non-parties. Multilateral conventions does not apply to non-parties by mere the fact that the large member parties have signed it. For its application to the non-party, it is necessary that non-party, by its conduct as a distinct evidence of its intention to accept provisions of the multilateral convention. Uh, Second one, the very important kind of treaty is treaty contracts. Contrary to the law-making treaties, the treaty contracts are not a direct source of international law. They are entered into by parties or signatories thereto. They constitute a particular law enforceable between the parties. But even they are a source of international law, and they are indirect source of international law. Uh, Three important considerations regarding treaty contracts. First one, the repetition of a treaty contracts providing the similar provisions of rules may produce a rule of customary international law to the same fact. The second one, a treaty fundamentally concluded among the limited number of parties subsequently may be generalized by independent acceptance or imitation. The third one, the treaties may have evidentiary value to the presence of rules which have evolved into law by an independent process of development. Thank you very much.